Corporations have all kinds of tricks at their disposal to dupe consumers into signing away their rights, and their favorite trick is to insert arbitration clauses into contracts. And if you've ever signed up for a cell phone, a credit card, or bought a car, or many other things, chances are you've already signed one of these agreements. Last week, Sam Seder spoke with Linda Lipsen about this issue, so let's take a look and find out why these agreements are so dangerous.
Let's start with this story that came out in the New York Times a couple of weeks ago. This is really a stunning story, and it's a perfect example of how something that we all think seems to be, rather pleasant sounding, arbitration, is being used as a weapon.
It's actually a corporate bullying tactic. It's in most every contract for products ranging from cell phones to nursing home contracts to your cable bill, tucked within the fine print is language that says something like, if something happens to the product, if something happens to you, you have to go to you have to agree to arbitration. And people sign these things there. They don't really know what they're signing. And, there's nothing wrong with arbitration as long as it's voluntary. And it happens, and you decide to do it after the injury or the situation that has caused you harm accrues. But you don't do it at the beginning of the contract. And, the problem lies with, there was a case out of Minnesota involving a woman who was on the reminiscence floor, the Alzheimer's floor, and they didn't have adequate locks on the doors, and she got out, and she froze to death. She got out. It was winter, and she froze to death. Well, that's wrong. And so what happens with arbitration is in this situation, the nursing home designates who the arbiter is, and the process of arbitration can happen. It doesn't even have to be in your hometown. It can be miles and miles and miles away. And the CFPB found that only about 9% of folks that get into these arbitration situations are even recover, even get anything. So the industry likes to say that this is cheaper and it's more fair, but it's actually rigged, unfair, and really unconscionable. And if you look at just sort of the 30,000 feet up issue, what you want to do is prevent this kind of harm from ever happening to another person. But the problem is that these arbitration kind of courts happen in secret, and you can't even appeal anything. So it is this is really a stranglehold on America's consumers. People are just starting to find out about it, and when you tell them, they can't even believe it, and they say things like, "This is just un-American." So we're trying to fix it by.
Well, hold on, Linda. Let me interrupt you for a moment and just make it clear. When you say CFPB, you're talking about the Consumer Financial Protection Bureau, and I want to just, before we talk about like what how you guys at the American Association for Justice are dealing with trying to rectify this situation. You point out there are basically two issues here. One is the issues on a practical level, and we saw that in that piece in the New York Times about what debt collectors are doing. They're going into the court system. They're using the court system to dock pay from people, to basically garnish people's wages, to send them to jail sometimes. But it can't go the other way. When these people try and strike back, they are still locked in these arbitration dynamics. And so you have that on a practical level. And then you mentioned the 30,000 feet level. It seems to me, like you're saying, it's the problem with that 30,000 feet level is that that if people have to have an understanding that what plaintiff attorneys do is that they form another regulatory structure in this country, which is particularly important at a time where we have all this revolving door stuff. Explain that to people, just how trial lawyers fit that function, and why then the corporations want to build in a sort of a a way of preventing trial lawyers from ever entering the equation.
Well, you can't tell a major company that treats their consumers unfairly to go to his or her room. You have to hit them in their pocketbooks. And what trial lawyers do is they represent individuals that are injured by dangerously defective products, or just people that are just getting ripped off. But it's not just for the purpose of making sure those people are compensated. The system itself works to protect the public from the injury happening to other people. So, as much as you would love to have regulation and a regulatory system handle all of these kinds of complaints. But, these agencies are all, they're underfunded, they're subject to political winds and things like that. And so you have to have a system of regulation and a system of civil justice that work hand in hand to protect the public from dangerous and negligent activities coming from corporate America.
In many respects, it's like the old Westerns where they deputize people. I mean, I know just in following the cases of the securities suits and the mortgage resolutions that the federal agencies all start with material that were found in discovery of private civil cases brought against some of these banking and mortgage fraudsters.
Absolutely. I mean, I'll give the best example that I can think of is has to do with cars. We are safer on America's roads today than we were in the 50s, and that even though there are more roads and more cars and more people, and the reason is, yes, the regulatory system has worked in some regard, but the reason is that because of what trial lawyers have done to bring cases to protect their clients, we have airbags and seat belts and roofs that don't crush upon impact, and windows that don't decapitate your kids. Things like this that are innovations that have occurred because of lawsuits, and that's all very positive. That's the story that doesn't get out. And I wish it was. We're proud of what trial lawyers have been able to do.
Right now in Congress, there are a couple of bills that are being pushed by the Chamber of Commerce because the one thing that corporations don't want is to be held to account for when they cut corners, when Volkswagen tries to design a car that fools the emissions testers as opposed to delivering the product they say, or whatever it is. Tell us what's being debated in Congress right now, and then let's talk about these arbitration clauses and what can actually be done about them.
Well, actually, today and tomorrow, there's a debate on a bill, H.R. 1927, that is in two parts. The first part would make it a lot harder for individuals injured by asbestos to be compensated through asbestos trusts. They made it very technical, but basically, the bill would just actually harass plaintiffs and prevent them from pursuing their claims adequately. In some respects, actually every respect, the bill requires individuals to tell very personal information and put it on a website, their Social Security number, how much they were compensated, things like that. And even Republican-leaning think tanks have said that the bill would violate basic privacy rights of individuals and lead to identity theft. And this is, we do not need to be harassing asbestos victims. We should be doing whatever we can to first rid the nation of asbestos, and second, make sure that people are no longer injured by this scourge that has been with us since the early 1900s. So, this is, again, it's the wrong focus. We should be thinking about how to prevent injury rather than how to harass people that are injured. It's just the wrong thing to do. The other thing that they're doing to add to this, I call this putrid anti-consumer stew that they're considering. Another thing that they're doing is they're preventing class actions from being brought by saying that individuals that are trying to join with other individuals that are injured have to have pretty much the same exact injury. Now, the issue with that is, no two injuries are the same. And so you're not going to get, the design is, the rhetoric, of course, is very simplistic on the side of the Chamber of Commerce and the defendant community. It's very simplistic, and they want to make it like, well, if you're not injured, you're not in the same way, you shouldn't be part of the same group. But class actions started out of efficiency, that you didn't want to have, all of these individual lawsuits. But also, if you're just ripped off a little bit, like let's say you look at your phone bill and it's $1 more than it should be, you can't file a lawsuit because it's not economical. But if Sally and Jane and Ted and others in your community have the same problem, you can join together and file a lawsuit. And the great thing is that activity, that behavior can stop. And that's the the regulatory function that you were talking about. And that's a very positive thing. We want to make companies really behave and really adequately represent the consumers that they're benefiting from. That's the way. I mean, they can save a lot of money this way too, by making the injury not happen in the first place. And they can save a lot of money by not spending it on PR firms and lobbyists, on going to Capitol Hill to try to convince Congress that the real problem in our society are consumers. I mean, that is silly.
Well, but the reality is, the flip side of that coin is that very often they are making decisions that are to increase their profits, and they are just trying to make a calculation. If we can lower the amount of accountability that is involved in here, if we don't have to pay out in response to what we save by cutting corners on certain products or certain safety features or whatnot, then that's a business plan for them. But so as you're lobbying against this, when we talk about, I want to jump back to what we were talking about in the last segment, which was arbitration. What can we do there? Can the Consumer Financial Protection Bureau say, like, look, we're not going to have arbitration clauses in contracts where there is such a uneven dynamic between the person signing, the company and the person signing that contract? Can the Consumer Financial Protection Bureau do something like that?
The Consumer Finance Bureau is about, we think they're about to initiate a regulation that will go a long way towards ending the abuses that we talked about, and in the area of financial products. So for mortgages and any kind of financial products, in addition to just having provisions in contracts that say you have to go to arbitration, they also say you can't join with your neighbor and set up a class action. And the Consumer Finance Bureau, it looks to be poised to initiate a rule that will make those contracts that say you can't aggregate a claim null and void. So that's very positive. I mean, the fact that there is an agency, a consumer agency, dedicated to making sure that the marketplace is fair and balanced, that's a very positive thing. And it looks like they're going to take potentially a very forward-thinking step. They're going to correct what some of the courts have done, and that would be very important.